Extreme enforcement by immigration agencies on H1B visas and F1 OPT student. Yes, you heard it right. Extreme enforcement by USCIS, FDNS, ICE, and many other immigration agencies. Increased FDNS H1B site visits, H1B visa revocations, USCIS secret fraud findings for F1 visa holders on OPT, deportations, 5-year bans, and much more. What are your rights? How do you realize your American dream and protect your visa status and your family rights? Well, welcome to Immigration and Jobs Talk Show. My name is Dan Nandan. I'm the president of Hire IT People Inc. I have contributed to the immigrant community for the past 15 years. I was also featured on mainstream media to include Computer World, Huffington Post, The Hindu, Economic Times, Times of India, and many more. To answer all your questions and understand the rights, we have an amazing guest on our show today, Mr. Jonathan Wasden, a top immigration litigation attorney. Mr. Wasden, a notable litigation attorney. Wasden's efforts have been instrumental in challenging and ultimately leading to the withdrawal of stringent USCIS policies regarding the H1B employer employee relationship and the controversial contract and the itinerary requirements. His work had a profound impact on the immigration landscape, offering relief and clarity to countless employers and visa holders alike. Not to forget his contribution to a major settlement requires USCIS to adjudicate H4, H4 EAD, L2, L2 EADs with I-129, which is helping many to obtain an EAD when concurrently filed with the Form I-129. So without further ado, let's welcome Mr. Wasden to the show. Hello, John. How you doing?
Good. How are you doing?
Okay. And thanks for accepting my invite on a weekend to help the community here. And before we get started, uh, by watching our videos, you agree and understand that the information provided by experts, attorneys, including comments by our users, is not legal advice. Use of information is at your own risk. So let's jump right in. So, John, you're pretty popular in the immigrant community as a top immigration litigation attorney and successful in filing class action lawsuits. Can you please share some background?
Yeah, sure. So it started when I was working for the government. I was in the Office of Immigration Litigation with the Justice Department. That's the office that goes to court and defends the agencies. Agency attorneys don't go to court. And so after doing that for a while, I went to work for the agency, USCIS, and I was at the Administrative Appeals Office there and dealing with a lot of litigation cases that were coming in on certain visa categories. And then in 2017, I think I'd had enough of the Trump administration already, and I just quit and started my own private practice. And so far, so good.
Okay. Just have a technical problem here. Just give me 1 second, guys. All right, so we are streaming live on Facebook, YouTube, and LinkedIn. If you have a question, we are talking about the FDNS site visits and problem students are facing specifically at the port of entry. Please post your questions as comments. I will take them right in. And after about roughly 15-20 minutes, once our topics are done, I will definitely take your questions and pass it on to John, who will be glad to answer your questions. So let's get started with what's happening here. This is an SOS message. Urgent. An F1 student was deported from Chicago airport while returning from a trip to India. He's on an F1 visa, and the CBP claimed that the college he attends is an online institution. Despite showing evidence to the contrary, they did not believe him. Can you provide any advice or suggestions on what steps to take next?
Yeah, so the Department of Homeland Security's dislike of many OPT programs or colleges that offer OPT programs and CPT is has a long history. It's been going on for years and years. And the trouble is with, you get flagged in their system, you leave the country, and then you come back through the port of entry. And that is one of two areas where you really just don't have a lot of rights, quite frankly. And so it's a difficult spot to be in. What I would say is prepare yourself with as much printed out documents as possible, showing your eligibility. If there's any questions about your situation, bring that with you to the port of entry. That way, if they ask questions, you can show them papers instead of just answering on the fly. The other thing I would say is never concede guilt in the port of entry when you get put into secondary. They will yell and they will scream. They will try and intimidate you. They will bully you. They will try to get you to agree to their version of events. And the more you disagree with them, the angrier they get and throw a tantrum. Don't get into that. That's a pressure tactic. They're doing that on purpose to put you on edge. Just understand that's what they're doing, and don't agree just to sign off on their paper, because it'll get you out of that office faster.
So that means there is no legal counsel. They can't get a legal counsel or an attorney, and they're trying to grab their phones, checking their emails, making them sit for hours.
Mhm.
Is there anything else that they can do in terms of trying to reach out to an attorney? That's not possible, right?
So they can ask, they say, I need to talk to my attorney. Whether or not the CBP officer will honor that request is another question. So, yeah, the rights and access to attorneys is not great in terms of your personal property, your phones, your computers, things like that. Unfortunately, the Constitution's protection against search and seizure that requires a warrant before you search doesn't apply at the port of entry. When you're coming through the port of entry, they can look at anything. And so there's not a whole lot of options. The only thing I would say is delete as many apps as you could on your phone, so there's nothing for them to go plowing through and looking at.
Okay, so you heard that, guys. So if you have unnecessary data on your phone, what's the reason you people are tagging on Facebook, Instagram, but that might be detrimental to if you are, the secondaries, they take you inside a room and they start questioning for probably hours and they want you to sign off a paper stating you agree. So you get deported. So you got to be careful. I would suggest you do your research before you flying back or flying for the first time. Now, let me just jump into this. Apex IT systems based in Delaware. So there are a lot of Apex companies. My apologies, I'm not referring to the other Apex companies. I know companies in New York. There are some top companies, but this is a specific company which is located in Delaware, which is at the moment it's hot news in reference to charging $200 and issuing employment letters for the OPT optional practical training. What is your take on this, John?
So the Apex IT systems is just the latest in a long line of these cases that scam students and don't actually employ them after they give them an offer of employment. Typically, there's some ploy that these companies issue with and say you have to go and get an additional training from us before we can place you at a client. And so you pay for that training, they give you the offer letter, and then you don't hear from them anymore. So that's the scam. It started as far back probably as the Integra raid, the DHS raided Integra, Wireclass, and Will, and AZ Tech. So, and Apex is just the latest in in the line. Apex, if you worked for Apex or really any of those companies I just listed, you are almost certainly flagged in the system with a fraud finding based on the OPT submission. And it's almost a certainty that you've got a fraud finding. So you need to really think carefully before you leave the country.
Okay, so let's jump into the topics in reference to the fraud findings to start with. I'm sure there are a lot of OPT F1 students who you definitely want to get more info. If you are watching somewhere, please share this live video. We are streaming on Facebook, YouTube, LinkedIn, and additionally 10 Facebook groups. So at Immigration Talk Show, please share. So we will enlighten the community to be safe. Now, John, what recent trends has USCIS observed in the OPT program fraud, and how is it addressing fraud, USCIS, especially with the students working in unrelated fields? Number one, I think that's the major problem. Although they're getting these letters as optional practical training relevant to their major or course of study, they're probably working at grocery stores, or they're probably working at gas stations. And what consequences do individuals and employers face when involved in OPT fraud, and how does this impact their immigration status and future applications, immigration applications?
So the reality is that the employer that is sponsoring the H1B or signing off on the OPT application, there's really nothing that DHS and USCIS can do to that employer. And so all of their enforcement efforts tend to be focused on the student, who in most of these cases is honestly the victim of the situation, and USCIS just piles on and victimizes them once more. So I don't see a whole lot of cases, to be honest. I haven't seen one so far where people were working in a completely unrelated field. Most of the people I know just have an IT degree and they're working in IT. So it's very luckily I don't have to deal with that out of specialty employment.
Okay, we're still getting there into your expertise in the litigation, because someone just called me. They said, "Oh, you're going to be interviewing uh, the litigation hero." So that was the word. That was a kind word. Now let's jump into the next one here, and we will talk about the litigations and the class action lawsuits. When you have trouble with your immigration case, or if there's a delay, there's a lot to go. And I see these comments coming in from many people here: Zara, Santosh, LinkedIn user, and I see one uh, about site visits. These are relevant questions. General immigration questions will not be touched today. If you want answers, we have right from Monday through Friday, same time, 12 p.m. Eastern time. There are other immigration attorneys who can certainly answer those questions. So please only post comments relevant to the topic. And I'm not trying to be disrespectful, but then we have a particular topic here that we're trying to focus. Now, John, what are the common reasons lead to the CBP denying admission? You touched this a little bit on my intro opening SOS question, but then if you can, go a little deeper, dive into this. What are the common reasons lead to a CBP denying admission at U.S. ports of entry, and how does this relate to fraud findings, including the F1 OPTs and H1B visas, and how does the inadmissibility process at the port of entry differ from other immigration proceedings while they're in the country, and what rights do individuals have during this process? You touched this a little bit. I would like to retouch this a little more detailed info, please. Thank you.
Sure. So the unfortunate reality is that before you even hit the port of entry, you've been flagged in the system, and USCIS DHS has put a fraud finding on your record in many of these situations. And they've done that, not from overseas, not at the port of entry. They've done that here in the U.S. And legally, they're required to, when they're making a decision in the U.S., to give the interested party, the person that's impacted, notice and an opportunity to respond. Because so many of these fraud findings that they're doing are incredibly shaky and indefensible in court, they're avoiding going through the legal process that they're required to do and doing the fraud findings in secret and waiting for you to leave the country and try and come back in only to find out that there's a problem. So that happens in a number of different ways. One is they can just wait for you to go on vacation and then hit you when you come back in. The other is the change of status denial. If you're going from F1 to H1, your status gets denied, but your petition gets approved, that's a pretty strong indicator that you got a fraud finding. So if the USCIS has put a fraud finding in the system against you, really the consulate should not be stamping your visa, and the port of entry won't allow you into the US. At the port of entry, they'll do one of two things. They'll give you a notice under 212A7, which is you don't have the proper documentations to enter the US. Or they could give you a 212A6, which is a fraud finding. The reality is, in almost all of these cases, that A7 finding is not technically accurate, because when you showed up at the port of entry, you had a legal visa, you had legal authorization to come into the US. They revoked it because of a fraud finding, and now you don't have papers. So the thing that they kind of dance around with that is that an A7 finding has a 5-year ban to re-entry into the US. An A6 has a lifetime ban. So people are thinking that they've got, this 5-year ban, when in fact it's a lifetime ban.
Okay, before I jump into the next topic, I have an interesting question here from Santosh. Many people are faking their resumes and experience, having 1 to 2 years of experience, and employers are calling to work on their W-2, adding 7 to 8 years of, just like as in the Apex systems or the Integra. I think they're probably this is somewhat relevant to those type of employers. Now, is this what USCIS is finding from the resumes?
So typically not. Typically the things that they're doing their fraud findings on are, if you work for a blacklisted OPT employer, or if your petitioning company had problems with USCIS in the past, and they suspect fraud in a prior application, they'll go through and they'll start looking for all kinds of different reasons to deny visas for employees of that company.
Okay, my next question actually it came in as a comment from Saurabh. Um, Hey, Saurabh from YouTube. I got deported under Section 212A7AI or L with 5 years ban due to Apex IT system. Is Mr. Wasden's litigation, will he be able to help me?
Hopefully. So right now we're building a case that we're going to be filing, and we're cutting off new plaintiffs next week at this time. And so that case is going after the question of whether or not the government is required to give you notice and an opportunity to respond prior to entering the fraud finding. And the reality is, like I said earlier, before you hit the port of entry, you had a fraud finding in the system, and all CBP was doing was just rubber stamping USCIS's fraud finding when they turned it around. So Our approach on this is not to argue whether or not you are innocent of fraud or guilty of fraud. We don't want to be dealing with the factual merits of the case. We want to be dealing with the procedural merits of the case. Did the government follow the proper procedure before they took action against you? The good news is, in my line of work, procedure, I'm an administrative lawyer, so we practice under the Administrative Procedure Act. And if you can point to a procedure that's been violated, courts are far more interested and likely to rule in your favor. If you're arguing about the facts, you're losing at that point. So we have a pretty strong argument that's on the process and the procedure. And then we're going through and we're taking those clients with the best stories to tell. That it's absolutely clear through their story that they did not commit fraud and yet have been penalized by the agency. The thought being in a large group case like this, you kind of can pick and choose how you're going to tell the story of your case, because you have a lot of co-plaintiffs with a lot of different stories to tell. So it's doing these group cases has a lot of distinct advantages.
All right, so this is something you're referring to, the class action lawsuits that you've been filing?
Mm-hmm. Yeah, so we've got one in Seattle. It's not a class action. It's more of a mass action or a group case. For a variety of reasons, class actions are not my favorite way of doing business. Mostly because they're slow and they're very expensive. And so if you want a quick resolution to a problem, avoiding the class action is definitely the way to go. But the first one that we filed was in Seattle with a group of plaintiffs, and most of these plaintiffs were outside of the US. Some of them were still in the US. Of the ones that are outside of the US, we're getting notifications constantly from our clients that the consulate has stamped their visa or before they're in 212 or 221G, and they've made it into the country. They made it to the port of entry. So that's, I think, a positive sign, and I think it's an indicator of how weak the government thinks their case is.
Okay, when you said, the consulates have, if I take an example of a student, let's say they pay $20,000 to a university, right? And then they get a visa stamped. They attempt to first time admission. There are not too many cases where they were denied the first time admission, or they were here, they continue to pay the fee, and let's say whopping $30,000 or $40,000, and they, for personal reasons, they travel out of the country, and they suddenly become inadmissible. So what happens to this money that was paid to these universities who don't want a refund? Is there a way they can at least get the money back, because they take high interest loans back in home countries and pay these, so sometimes it's fictitious universities or online universities, just like the question we've had. So would this also be a part of litigation to send a subpoena to the university to get at least collect the money on behalf of the students?
So a debt collection action like that, and really in a case alleging fraud, is really something that is going to be specific to the state where that college is located at, and it's going to follow the state's law. I do federal law only. I don't really do any state law. So because my practice is all federal, it wouldn't be something that we would do. But if you have a large number of people that are impacted, a plaintiff's attorney would love to take that case, because they work on contingency. They don't get paid unless they win. And if there's a lot of people that paid a lot of money, there's a lot to win.
Okay, thanks for answering that. Now let's jump into the most important USCIS H1B FDNS site visit program, and we'll get started with basics of what is the FDNS and what is its role in H1B regulations and how does it conduct compliance reviews. Is this like they have bunch of applications they just pick up, or it's a random process, and what triggers the random process, site visits, and how frequent are they? I've been hearing it, they've been pretty frequent now. And what are the procedures that are followed during FDNS site visits, and how should employers and the H1B visa holders prepare?
So, in terms of the site visit, you have an absolute right to counsel or an attorney in administrative proceedings. A site visit is an administrative proceeding. So, I would say you should always have an attorney between you and the agency when you're dealing with the FDNS. In terms of what is FDNS, it's very unique in the federal government structure. So ordinarily, if you're going to be creating a sub-agency like that, you have to get something in the statute, something authorizing it in law before you can spend the money. So the way, before we had the INS, which was the judge, jury, and executioner of immigration law. In 2003, they split the INS's function into a bunch of different agencies. Now, USCIS was delegated explicitly only the authority to adjudicate. The authority to investigate was delegated to ICE. The way that system was supposed to work was that USCIS would suspect fraud, they would refer it to ICE, ICE would investigate, and then USCIS would get the results of the investigation. The reality is that the things that USCIS were referring to ICE were so trivial and so stupid that ICE didn't want to deal with it. They were actually looking at real fraud. And so the USCIS referrals just went by the wayside. Nobody was acting on them. So they looked at their budget and they said, we don't have to go to Congress for money. So what we'll do is we will divert money from hiring new adjudicators and paying for facilities to adjudicate petitions. And we will create this internal police force. And that's what they did with FDNS. And they did it without regulation. They did it without statute. And it just pops up out of nowhere. Coincidentally, at a time when they're facing the longest backlogs, I think, in immigration history. So, the FDNS has gone up to over 2,000 employees in the last couple of years. The 2,000 adjudicators could have done a lot for all these backlogs.
And the FDNS typically, when they began this program, this was more contractor based, correct?
Yeah. So for FDNS, once you get approved, your visa petition approved, then your receipt number gets put into what is an allegedly random selection process. And if you get selected for the site visit, then FDNS contacts you or the employer. So the reality why they do the fraud detection on the back end is because there's a court order against them saying that they can't consider certain things on the visa petition adjudication. But it's just clear that it's adjudication of the petition. What USCIS is doing is they're enforcing those same rules that the court prohibited on the back end and through the site visit process. And so that's why they do it in that sequence.
Okay. I do see a lot of chats once again, friends. I will definitely take those questions which are relevant to. We jumped into the FDNS H1B site visits, and if you still have questions about your rights litigation, if you need help from John Wasden, his number and the email is right on the screen. You can also visit their website at wasden.law, WASDEN I still have a lot of questions here. We are already almost 30 minutes into the show. We'll try to go as quickly as we can. And, thanks for, I see some comments coming in from India as well. Thanks, folks. I know it's pretty late. We will definitely do our best to take those questions. But then, if your question, I haven't taken your question, we will definitely cover these in the next upcoming general immigration shows. I will also flash my phone number and my email, so if you need help, you could just send it over to me. Now, my um, next question here is from um, Santosh once again. It's interesting, going back to the Apex IT. So there will be another Apex IT system. How can I find a legal employer as Apex got EIN number with all approvals from the government? True, they could just float a company in Nevada and still get an EIN number. And how do we check the whether if the company is fake or not? And please don't say it is from Google or LinkedIn, because in both things we can simply, it's the comment is cut off on the screen, John. I'm going to read it for you. It's interesting comment. um, I don't want to say LinkedIn or Google it, because in both ways we can simply create accounts and all add all the details. Is there any way to find the company or the employers are genuine? As see, there are on LinkedIn, so many members are going back to the same fake experience. Please, Dan, talk about this. Sure, we will try.
Yeah. So, in a grand display of how ineffective DHS is, they created the E-Verify system. It was supposed to be a resource for students to go in and DSOs to go in and say, okay, this is a legit company. They passed DHS's tests. DHS has certified them as legit. I can work for them. All of these companies that we're talking about, these scam companies, they're still in E-Verify showing up as valid legal employers in the US. And DHS has the ability and the authority to publish the list of all the companies they think are blacklisted. And that would help the student population immensely by avoiding scams. But they don't. And they let people stumble into the traps that are already there. In terms of what to do with the next scam company that pops up, I would say if any company that's asking you for money for training, stay away from, because that is going to bite you in the end. Any company that's asking for money for an offer letter, run away. Don't mess with them. Don't waste your time. And really, as a general rule, anybody asking for you to pay them money to work for them is not somebody that you're going to be wanting to deal with.
Okay, to add to that, John, this is very interesting. Yesterday, someone sent me a few messages about, will definitely, I really want your inputs on this. There was a company operating, seemed to be operating from some European country, sends an offer letter, and the offer letter states, we are going to pay for your equipment to the vendor, and you'll get paid $75 an hour, and $7,000 is going to be spent on your name to get the laptops, Apple laptops, and so on and so forth. This money will be deposited into your account. Looks like they will deposit a fake check, international check,
Mhm.
and takes 15 days or 3 weeks for the bank to process, and then they will request you to pay the vendor of that $7,000, and you're done. So have you seen anything like this within your, because I'm sure you've been getting a lot of complaints and a lot of emails and a lot of networking. Is there anything, you have anything to say on these type of whimsical acts by the scammers?
So I haven't heard of that particular scam. Usually the things that I hear about are, have resulted in an adverse action by USCIS or one of the immigration agencies against the person. In that situation, that's really a civil issue between two different private parties. And so it typically doesn't raise to my level. But the foreign check scam is one that I think everybody's got an email from a Nigerian prince. They say they're going to deposit a whole bunch of money in your account, and then you give them your bank account information, and boom, your bank account is empty. And so I just, myself personally, I'm too risk adverse. I wouldn't be giving my bank account information to somebody that I did not know and trust implicitly.
Okay, so before we jump into the next question on the FDNS site visits, you were successful with the receiving the H1B employer-employee relationship memo.
Mhm.
What did it take to get this whole process done? Was this like a mass litigation by employers? I know it's from IT Serve Alliance, a lot of member companies. I think a bunch of us tried to support this whole issue. But what was your experience, and what do you see that's upcoming? Because there's a new H1B modernization program. Do you think the immigration or the USCIS DHS is going to swing back and add more items to the employer-employee relationship once again? And if so, would you be willing to fight that once again?
Mhm. So in the case you're referring to, there was really two different issues that we took on. One was the process of USCIS denying or curtailing visas because lack of existence of a project. And then the other was the employer-employee relationship. Those two issues had another layer of difference in that the employer-employee relationship test that they are running was completely contradictory to what the regulation says. And the agency has to follow its own regulation. It's not something that they can just ignore. And because it was obvious and directly in contradiction, the court really didn't have a whole lot of trouble getting rid of that rule. Now, the non-productive work or the existence of a project issue equally died, but on stronger grounds for us, which is it's in the statute. And if you've noticed, Congress isn't really doing anything these days, so there's not going to be any change to that statute anytime soon. So the law allows people to be in a non-productive status for lack of work. It's very explicit. It anticipates that there's going to be times you don't have anything to do. The law also requires that you get paid during that time, but whether or not you have a project is completely detached from whether or not you're maintaining status. And USCIS, I think, is coming out with this new modernization reg, and they're going to take mega tax on both of these different losses that they suffered in court. They can change the regulation on the employer-employee relationship to some extent. I think they're going to be limited because the Department of Labor is really the one that's the expert agency in this field in terms of defining who's an employer and who's the proper signatory to the LCA. So I think there's going to be some statutory problems with any definition that they come up with. They can do all they want in regulation, but if that regulation contradicts the statute, they're done. And I think that's the problem they're going to be running into with trying to figure out ways to shorten the visas or not approve visas that don't have evidence of a project.
And for my viewers, can you explain what is a statute and
So,
in legal terms, in layman terms, please?
no worries. All right. So a statute, there's three different layers of federal law that are important. Constitution, which is supreme. You can't violate the Constitution if you're the government. You're not allowed to. Now, under the Constitution are statutes, and that's what Congress creates. Congress, they vote, if both houses approve and the president signs, that's a statute, that's in law, and the federal government has to follow it. Now, from that statute, oftentimes agencies are given authority to create regulation. And so they take their statutory authority and they make a regulation, but that regulation cannot contradict what Congress has already said. And so that's why I think we're in a good spot with them changing the regulations, because there's things that Congress has said that they can't run away from.
Okay. Thanks for that detailed explanation on this lingo. I will jump into my next question on the FDNS site visits. I do have a few questions. We're running out of time. I'll try to be as fast, as quick as possible. What rights do employers and H1B employees? I know you touched this a little bit, have during FDNS site visits? And can they refuse participation? And how can employers verify FDNS officers' identities? Now, there are a lot of scams. Somebody can knock the door and say, because they don't come in like a uniform with, they probably have a badge. Anything can be fake. So, how do they, verify the credentials, and can the employers or the H1B site holders um, refuse the participation?
It's funny because the site visit process, according to USCIS's own website on FDNS, is a voluntary participation program. And you're not required to participate. And if you refuse to participate, they're supposed to actually stop the site visit. They're not following their own rules on that last part. But the first thing that I do when I'm representing somebody that's going through a site visit is I highlight and send them a copy of a screenshot of that website saying, all right, so your voluntary process you want us to participate in. We might tell us what you're looking for. There are certain things that I will never give them, and that is information about pay, because I've seen crazy examples where USCIS has gotten information about pay. The worst one I've ever seen was a W-2 where the employee was paid $19,000. The wage on the LCA was $120,000.
Wow.
USCIS revoked the visa for failure of the employee to maintain status for not getting paid fully. There's any number of reasons why there could have been a legal shortchange in wages that way. But regardless of what the reason is, an employee really shouldn't get punished for something that is completely beyond their control. And so, that's why I don't give pay. The other reason I don't give pay information is because Congress gave the authority to set wages and enforce wages to one agency, and it wasn't USCIS. It was the Department of Labor. And the Department of Labor is not allowed to go in and randomly ask for information about pay for your employees. So if the Department of Labor, who is the only agency with authority in this area, can't do this, why does USCIS think they can? And so, that we push back on that all the time. I would say for most H1Bs, let me take a step back. With a fraud finding, you have to have an affirmative communication between yourself and the immigration agency in pursuit of an immigration benefit. And you have to know that that communication was false at the time it was made. In the H1B petition process, you as the employee are never communicating with the government. In fact, there's a rule in the regulations that says they won't accept any communication from you. And so in the petition process, it's almost impossible for the employee to commit fraud because everything is sent by the employer. The site visit process is the only time that you as the employee are really going to be directly interfacing with the US government immigration agency. And that's really where you're most susceptible to them issuing a fraud finding. Sadly, you can't trust on them to accurately summarize things. You can't trust them to follow the rules. And I've seen we have documentary proof where FDNS officers have lied in the report that they sent to the service centers that ended up in a notice of intent to revoke. And we had emails going back and forth with that same officer that proved he was lying. So I don't trust the FDNS any farther than I can throw them. And so I wouldn't, for the listening audience, I wouldn't trust them either. The
Okay.
one of the easy ways to get out of that conversation is kind of what you alluded to earlier, was if they show up at your house, you do not have to let them in. But more importantly, you don't have to talk to them. But if you're uncomfortable getting out of the situation, just saying, you know what, there's so many people out there scamming immigrants. I don't know if you're legit. I can't vet you. But you know what? My attorney can. My attorney will be able to figure out if you're legit and much faster and easier than I can. So why don't you talk with them? Ideally, it's you would have an attorney already on the hook for that. But if you don't, buy some time to get some. Just take their card and tell them you'll have your attorney get in touch with them.
So viewers out there, if you have a site visit, and the site visit, these days after post COVID, there's a lot of specifically in the IT industry, there's a lot of work from home. So when you work from home, do some homework. Keep You never know, they might just knock your door. You can definitely reach out to John's office. I have the phone numbers listed on the screen, but people who are just listening to this, the phone number is 703 216 8148, and his email is John, Jon, there's no H, Jon at Wasden, Wasden dot law, LAW. So John, would you take, if somebody has trouble with the FDNS, there's, somebody knocks at the door, and, if, let's say, the officer is little, they're trying to harass, uh, and, as you just stated, there could be a bunch of lies. Now, assuming the officer is legit, can the H1B visa holder connect with your firm, or they have to come through their employer? How does it work?
No, so the site visit process could be done under the auspices of the employer, and a lawyer can represent employees of the company with just the employer's G28, the notice of appearance of counsel. That G28 is the only document that allows an attorney to talk to the agency on your behalf. If you don't have it, they won't talk to you. So the employer can just have a blanket G28 for all of the employees, or they can just have one G28 just under the company's name, and everybody kind of derives a benefit from that that's an employee. If the employer doesn't have an attorney doing FDNS defense work, or if you're not really comfortable with the one that you're dealing with, you can get your own attorney to handle the case.
Okay, guys, you heard it. If you're on an H1B, there is a possibility, every possibility that you might have a random visit. So John has, looks like it's a subscription package. So you can ask your employer to connect with John's office on the phone numbers listed. John, I do have another, just going back to I have a comment here, going back to Apex once again. It looks like there are a lot of Apex folks out there. This is from Rajeshwari Chowdhury. My visa got revoked under, the same question as before, 212A, because of Apex IT. I was there for only 2 months when I was on an OPT. Can I still work in the US for my current company? Is it legal? Maybe she's overseas, right? So the visa is revoked.
Yeah, I mean, if you're overseas and your visa is revoked, you can continue working it from your home country, but you're not going to be getting into the country.
Right. Okay, so I'll quickly jump into my next question on the topic. And what type of document requests can FDNS make? You touched this a little bit, but then um, they might ask for a lot of documents. But as you know, they when they come in, they're again asking for the um, uh, educational documents, identification, sometimes pay stubs, sometimes offer letters. But isn't this a burden on employers, which was already submitted to the USCIS at the
Yeah,
time of petitioning?
yeah, it's a huge burden and redundancy, and it's really just to harass people. There's really no other legit reason for it. The things that they're asking for in the site visit process, like you say, evidence of pay, which we never give them, offer letters and contracts with the client, which we also never give them because the court order prohibited them from doing that on adjudication. So we just push it back on them and say, if you can't do this at the beginning of the process, it's really not relevant to the end of the process, and refuse to give that to them. If you look at the way the statute created by Congress is structured, it splits authority between a couple of different agencies in the H1B world, one of which is USCIS and one is DOL. And USCIS's authority is super, super narrow compared to the Department of Labor's. And they only are really on the hook for answering three questions. Does the occupation require a degree in a specific specialty? Does the occupation degree a highly specialized body of knowledge? And does the employee have the knowledge in the degree? That's it. So the only things that we ever give them relate to those three questions: degree, knowledge, things like that. Anything outside of that, we refuse to give them.
All right, pretty well. We have a running short of time. John, I have one more question. And for people who have been posting questions, a little different from the topic today, I'm posting my contact info right on the screen. You can send me an email, or you could just send me a WhatsApp message. We'll try to get them covered. And if you need any additional help, I'm here. Um, and Now, jumping back into my last question on the FDNS, what type of questions do FDNS officers ask? And if someone wants to voluntarily participate, now what are the do's and don'ts? Should they be detailed, or they should just wait for the attorney to engage an attorney, and then somebody like you, and then start responding to the FDNS site visit officers?
For a variety of reasons, I would say you're better off having a lawyer handle this for you. So the main one being that it's the only time you're going to be communicating with immigration officers. It's the only time you can really be found to have committed fraud if they mischaracterize whatever you told them. So that's the first one. Can you repeat the second part of that question?
Right. So if someone's like, they have, there was a site visit, including at that point they're talking to the either the site visit is at the employer's office or work location, and what type of responses should they be prepared for, and
Okay.
should they be detailed, or they just wait for the attorney to engage and involved during the process. And during the if they started asking too many questions, can they stop and say, I don't want to answer these questions anymore, just to
Yeah.
refresh?
It's a voluntary program. You can stop it at any time, and you don't have to participate. You don't have to talk to them. You can say, talk to my attorney, we'll handle everything in writing. They don't like doing that. Every time I tell them we'll handle it all through the writing, they get a little bit unnerved by that because it's very hard to lie about what's in black and white on a page. And so they don't like that. But so they'll always try and coerce you into talking. Now, the questions that they ask when they show up for the site visit are probably in large part going to be based on whether or not there's something they think they know is going on versus a truly random inspection. When FDNS thinks that there is evidence of fraud out there, they will go and they'll ask questions, gather information, all with a goal of procuring evidence to prove the fraud finding. In the regular site visit, they're just shooting in the dark. They're just giving like the standard long list of questions. Regardless of what happens during that site visit, if they think they know something beforehand, they are going to try to revoke that visa no matter what you do, whether you participate, you don't participate. The big difference is that when they try to revoke, they have to issue a notice of intent to revoke. And if there is what's called derogatory evidence in the record, they have to give you that evidence. They have to tell you what they think they know. And then you can respond and be a little bit more strategic and narrow in your response and not give up information that could be construed to hurt you. That requirement to give you evidence as adverse information or derogatory information does not apply to the site visit. It only applies to adjudication. So you're much better off not participating if you have any questions, and having either your attorney do it or waiting to see if they think they actually have something on you and you can fight it in an arena what is more favorable to you.
Okay, so before we conclude this session, now when you said there can be a notice of intent to revoke, which is coming from the not the field office, the service center, can someone engage your services at that point? Is it that too late? And the secondly, now after they have responded to the intent to revoke, if the petition is still revoked, is there a possibility to litigate this matter in the court of law?
You can definitely litigate revocations of non-immigrant visas.
Okay.
Revocations of an immigrant visa, which is much more valuable to you, you can't sue about, which I've never understood the distinction in the law, but that's what Congress said. So, sorry. And then the notice of intent, you had a question about the notice of intent to revoke?
Right. So if there was a notice of intent to revoke, so my question A is, can someone engage your services? Would you be able to help when there's an intent to revoke, or they have responded to the notice of intent to revoke, now the petition is revoked? Can you still help them after the petition has been revoked by the USCIS?
Yeah, in terms of hiring us after the NOIR comes out, yes, that's possible. The difference is that because it's dealing with the petition's approval, the employer is the only one that the agency will recognize as having an interest. And so your employer would have to sign the G28 authorizing me to respond for them and for you. If it gets past that point and it gets revoked, that's very easy to challenge. That's something that we do all the time.
Okay. And before we end this session, John, you have any golden tips to summarize your services and the fraud findings and how best you can support the immigrant community?
Yeah. I would say just be very, very cautious when you're dealing with anybody from the immigration agencies, and default to silence instead of talking. Their whole goal is to get you flustered, to come in, scare you, whether it's CBP or whether it's FDNS, and put you on your back heels and get you babbling. Once you've kind of lost that mental acuity, they can kind of manipulate your statement into anything that they want. So don't put yourself in that situation. Let somebody stand between you and them. And I get that, there's a huge cultural difference that I fully appreciate. I grew up in the Western United States, literally shooting guns off my back porch, and we hated the federal government. We just had nothing but despise for them. And so it's very easy for us, kids that grew up in the Reagan era, especially in the West, to push back on authority. It's just natural to us. Not all cultures are the same. If you're not comfortable pushing back against authority, have somebody get between you and the authority that is.
Okay. And thank you, John, for accepting my invite and spending almost an hour to patiently explaining. And thank you, viewers out there. Don't forget to subscribe to Immigration and Jobs Talk Show. We'll come back with another episode if John has time. I would love to have him again. As and when things happen, I know there's a lot of enforcement, so you got to be careful. And if you need assistance or services, if you want to, if the case is extreme, I would definitely think, if your case is getting extreme, do the damage control, please reach out to John. John, thank you and have an amazing rest of your day.
Cool. Thank you.